Hello, I'm Alice, your virtual drawback assistant. Today, we will be discussing the topic, unused merchandise drawback. Unused merchandise drawback applies to imported duty-paid merchandise that is exported in essentially the same condition. For example, a company imports vehicles into the U.S. and pays duties and fees to Customs and Border Protection. Some of those vehicles are sold and then exported to Canada thereafter. The vehicles exported in essentially the same condition to Canada qualify for unused merchandise drawback and are eligible to be matched against prior duty-paid imports. Within unused merchandise drawback, there are two methods to match qualifying exports to prior duty-paid imports that designate a statutory filing provision. Those two provisions are 19 U.S.C. 1313J1, known as unused direct identification, and 19 U.S.C. 1313J2, known as unused substitution. First step is direct identification. The simplest way to think about it is matching imports to exports at the part, SKU, or material level. To compliantly use this method, Customs requires lot or serial number tracing. For example, a vehicle has a unique serial or VIN number. That number allows the import to be tracked into inventory, show being withdrawn from inventory, and then exported. The item maintains its identity throughout the process, and that's what we call explicit matching. But what about retail apparel? Clothing doesn't come with serial numbers. In cases like this, Customs allows companies to use a drawback accounting method. This is a fiction of your drawback program and essentially a structured way of turning inventory for drawback purposes when lot or serial tracing isn't possible. The second matching method is HTS level substitution. With this method, duty-paid imports can be matched to qualifying exports that share the same 8 or 10-digit classification. That's right, we can ignore part numbers entirely. Domestic, manufactured, or even duty-free exports, regardless of their origin, can be substituted against duty-paid imports if they have a qualifying HTS match. This method offers broader flexibility of claiming drawback. However, there are a few rules and restrictions with unused merchandise substitution that we'll touch on next. Let's talk about those unused merchandise substitution rules and restrictions. First, there's the other classification restriction. If an 8-digit HTS description begins with other, it's considered too broad for substitution. In that case, we then must move to the 10th digit suffix classification. If the 10-digit classification also begins with other, then unused substitution is not allowed. In that case, we must file under unused direct identification and match at the part, SKU, or material level. There's also an export destination restriction under USMCA for Canada and Mexico and a free trade agreement with Chile. If a duty-paid import is exported to Canada, Mexico, Chile, or any U.S. territory, we cannot use unused substitution. In these cases, we again have to file under unused direct identification. Now let's cover a common rule. It's called lesser of two values, which applies to unused substitution. When substituting merchandise, you can only claim drawback on the lesser of the import or export value. For example, if you import a duty-paid item valued at $100 and match this to an export valued at $50, you would only receive drawback on the $50 value, or half of the duty you paid. It's important to substitute similar value exports. Otherwise, you can leave significant recovery opportunity on the table. I want to thank you for joining me today, and I hope that I provided a better understanding of unused merchandise drawback. At Alliance, we're committed to empowering professionals and businesses alike through drawback education. Be sure to explore our other videos covering additional drawback topics or reach out to one of our drawback experts with any questions. We're here to help.